Welcome to the Topics in SSI short video series. I am Trinh Phan, Director of State Income Security at Justice and Aging. I'm here with Jennifer Cronenberg, Senior Counsel and Director of Legal Information at the National Organization of Social Security Claimants Representatives. The Social Security Administration has been very busy recently, making changes to improve the programs they operate and to improve the service they provide to the 70 million people who receive benefits administered by SSA and the millions who are in the process of applying. At Justice and Aging, we started this series to share information and insight into the changes at SSA in short segments that are easy to incorporate in your day. Today, we are sharing about significant changes SSA has made to disability-related rules. Social Security disability programs provide benefits to over 11 million individuals with disabilities. These individuals receive SSDI or SSI disability benefits after they have been found disabled under the stringent definition of disability that SSA uses. Thank you, Jennifer, for joining us. The Social Security Administration recently changed the way that they consider past relevant work. First of all, what is past relevant work and why does it matter for a Social Security disability or an SSI disability claim?
Sure. So when deciding whether someone is disabled, Social Security uses a 5-step process. So first, is the person working? Second, do they have a severe medical condition? Third, does their condition meet very specific criteria that necessarily means they're disabled? So those are usually called listings that they meet. But third, fourth, if you don't meet one of those listed conditions, are you able to perform any of your past relevant work? And if Social Security decides that you can perform any of your past relevant work, then they'll declare that you are not disabled.
Considering that many people have multiple jobs in their lifetime and even several jobs at once, how did SSA determine what qualified as past relevant work?
So prior to the recent change, Social Security viewed past relevant work as any work that the claimant had performed for the past 15 years that was substantially gainful and that lasted long enough for the claimant to have learned how to do it. So in every case, the claimant, sometimes with the help of a representative, would have to fill out forms detailing all of those jobs that they had done for the past 15 years. And 15 years is actually a really long time if you think about it. So especially if you work in retail or in a restaurant or construction, something where you might just naturally go from job to job, that's a lot of information that you're having to list and a lot of information that the agency is having to process and fill in gaps on. So it was a real burden, both recalling the information for the individual and for processing it all for the agency.
So we have already mentioned that there was a recent change. What did SSA decide to change?
So they made 2 substantial changes. So first, they changed the relevant work period from 15 years to 5 years, meaning that people now only need to list the jobs that they've had in the past 5 years. And Social Security will only consider those jobs when they're deciding whether or not you're able to perform your past work. So that's a huge change. It knocks off a huge chunk of time. So the second change is that they decided that work was no longer relevant if it lasted less than 30 calendar days. So that's really helpful for people who might have had temp jobs or something, jobs that they did have long enough to learn how to do, but not jobs that lasted for any substantial period of time.
And when did this change take effect?
So it went into effect on June 22nd of 2024. And it's the decision date that matters for these cases. So any case that was decided on June 22nd or after will have used and will be using that 5-year past relevant work period.
You mentioned step 4 of SSA's decision-making process for disability cases. Can you talk a little about the impact that this change has on step 5?
Right. So Social Security, since they're only looking at the past 5 years of your work history, they'll first make that decision at step 4 about whether or not you can do any of your past work. So if they find that you can't do any of your past work, they move on to step 5 and trying to decide whether or not there's any other work that exists in the national economy that you're capable of performing. And they have different rules for different age groups and different skill sets. So for some people, there's jobs open to the entire national economy of employment. But as you get older and you have fewer job opportunities, Social Security has really specific criteria that they look at. So for example, if you have someone who's over the age of 50 and they're physically limited to sedentary or sit-down jobs, or if you have someone who's over the age of 55 and they're limited to light exertional level work, and Social Security finds that they can't do any past work, Social Security would then look at whether or not they have transferable skills from any of their past work into other similar jobs that do exist in the national economy. So previously, under the 15-year rule, you might have had someone who was 54 years old and physically limited to a sit-down job, to sedentary work. And let's say they've done the more or less the same job for that whole past period of time. Let's say they were a hairdresser or something where they had to stand up a lot and they were using their hands. It was a really physically demanding work. But 13 years ago, for a few months, they worked as a secretary or something, a sit-down job where they did learn skills at a sit-down level, albeit quite a while ago. Previously, Social Security could have denied that case, basically saying, okay, now you're limited to a sit-down job, you can't do your hairdresser job, but 13 years ago you had this one job that you did, and whether you remember it or not, we think you have skills that transfer from that job into other work, so you're denied. So that's how it was under the 15-year rule. But now, with only 5 years, that past work would be excluded. So it's a big change for a lot of folks where they can't look at that remote work that you did and decide they are able to do other work because of it.
Yeah, this sounds like it's a win for claimants and for the agency, just having a lot less of a burden to develop the record and find out about all of the past jobs and whether the person has transferable skills.
Right, and it just makes sense because like with technology, so many professions are changing so quickly that even something you did 10 years ago might look totally different today.
And since you mentioned technology, that brings me to my next topic, the Dictionary of Occupational Titles.
Yes, the ever popular resource that Social Security still relies upon.
Right. So SSA uses the Dictionary of Occupational Titles, or DOT, to define what jobs exist in the national economy. And I think it was last updated in 1991.
Right, and that's before most people were using computers on a daily basis.
But there have been some recent developments with SSA and the DOT. Can you tell us about that?
Yes, so in June, Social Security issued 2 emergency messages, and they were about what we call obsolete occupations, basically jobs that don't really exist anymore in the way that the Dictionary of Occupational Titles describes them. So the first emergency messages provided a list of 114 jobs that Social Security classified as isolated. So these were mostly largely skilled or highly skilled jobs, so really, really specific occupations that Social Security does not cite to very often. But nevertheless, Social Security said that we're not going to rely on these jobs anymore in order to deny claims because they are just so incredibly isolated. It's not something that is a significant job that exists in this economy. So they kind of got rid of those jobs as something that they can look to. The second emergency message was about 13 jobs that Social Security does frequently cite to. So these are jobs like a dresser or document preparer, tube operator, surveillance system monitor. So if you operate a lot in this space, you've probably seen these jobs a lot in your denials or in your hearings. These are common ones that vocational experts cite to and that judges cite to in denials as well, finding that folks can do these jobs. So the problem is the federal courts have taken issue with these 13 jobs specifically, finding that they don't really exist in the way that the Dictionary of Occupational Titles says that they exist. So there have been a lot of remands for cases that rely on these jobs. So this new emergency message kind of recognizes that. And unfortunately, it stops short of saying that they should stop using these jobs altogether. But instead, what it does say is that a vocational witness, if they're going to rely on one of these 13 jobs, then they have to provide additional evidence that the job matches the individual's residual functional capacity and that the job does exist in the national economy in significant numbers, either alone or in combination with other cited occupations.
Yeah, so it sounds like some improvement, but likely still more remains to be done. Let's move to another change that SSA recently made. They updated their rules on collateral estoppel. First of all, can you share what collateral estoppel is and when it applies?
So collateral estoppel generally means that if an issue is decided, it can't be decided again. So for Social Security's purposes, if they had previously found someone disabled, for example, if you had an SSI or a Title II recipient, and then that person becomes eligible for disabled widows benefits under a higher amount after the death of their estranged spouse, for example, or if you had a disabled adult child who was receiving child disability benefits on one person's account, like a one parent's account, and then they became eligible for a higher benefit amount on the other parent's account. When they apply for that new benefit type to try and get that higher benefit amount, Social Security should be able to award the benefits without making a brand new determination about their disability.
So what was the change that SSA made in July?
So for the past few years, even though Social Security was applying collateral estoppel, they were transferring these cases from the field office to the DDS, the Department of Disability Services, for a full disability determination. So they were having a full workup, which was really wasting valuable time and resources as they essentially determined again whether or not these folks were disabled, even though they were already on disability. But with July's change, now the field office can apply the prior decision without further development. So that'll lead to quicker decisions, which is better for the person and for the agency.
Yeah, what about if a person was awarded in the original claim but based on a listing, and then that listing has changed since the original award?
Yeah, so that's a great question. And so this was actually happening a lot when the mental listings and then the back listings underwent substantive changes recently in the past few years. So many people that were applying for these secondary benefit types or the new claim, they were reevaluated with the new listing criteria. And those claims ended up getting denied, even though they were already on benefits. So this was creating a lot of unnecessary confusion. So if, let's say they were awarded originally on a listing, found disabled, still receiving benefits, then when they applied for this new claim, they looked at it, the DDS looked at it under the new listings and said, well, you don't meet these criteria. So now this claim is denied, even though we already think that you're disabled on this other claim. It was really confusing and it was wasting a lot of time and taking up a lot of resources. This change, because a claim won't be reevaluated by DDS and the field office is just applying the decision, even if the listing changes, because there's no determination being made, assuming that all of the other rules apply, the new listings won't apply and won't affect the determination of disability.
Yeah, that sounds like a really positive change for claimants. I know many people were confused and frustrated when these cases were being put through a full disability determination. Does it apply in all cases where someone applies for a different type of benefits if they are already on benefits?
No, so there are several technical requirements. So the old and the new claim must cover the same period of time. There must be no cessation based on medical improvement. There must be no termination on the prior claim whatsoever. And there cannot be any SGA between the two claims. And there must be no reason to believe that the initial approval was made in error.
Yeah, so we talked about some pretty big changes, both with the past relevant work and with the collateral estoppel. These both seem like changes where someone might have received a denial earlier this year that would have been an award with these rule changes. Does SSA have any type of policy or plan for these people?
Yes, so when there's a substantive change in policy like there are with these, Social Security typically issues guidance regarding whether or not they can reopen prior claims. And they've done that here. But in general, when there's a change in policy, the general rule of thumb is that claims can only be reopened within 1 year of the initial denial. So if you were denied at the initial level within the past year, and either of these rule changes would have resulted in an award, then you should request reopening, which must be done in writing to the agency. And then they should reopen your claim with the same original application date and onset date.
So that's good for people who are early on in the application process. What if someone is later in that process and was denied at a hearing earlier this year? Let's say your example of the 54-year-old who did some secretary work a decade ago. Is there anything she can do now to have access to these new rules?
Yes, so there's a couple of things. So one, if she's still in her appeals council window, she should appeal that. We haven't seen enough of these cases yet to know for sure what the appeals council is going to do, but we have seen a couple that have confirmed the denials. So even if the AC denies review, though, and confirms the denial, an appeal to the federal court might be warranted. There's some evidence that federal courts don't like this kind of arbitrary nature of, well, yesterday it was a denial, but today it's an award. We saw a recent case that came out of Nebraska, district court in Nebraska, that did remand one of these cases. So there's some hope there, although we don't have really enough evidence to know what the appeals council or the federal courts are going to be doing. But the second thing that she should do is she should file a new claim, because Social Security has indicated that res judicata will not apply in these past relevant work rule change cases.
And just to remind everyone, res judicata, very similarly to collateral estoppel, means that once a matter is decided, it can't be decided again. So here, because an ALJ found her not disabled, if we assume that's the final decision, is it that any new claim would have to be for a period of time after that ALJ's decision? Is that right?
Right, so that's how it normally works. So if you got denied at a hearing and the judge said you're not disabled and you wanted to file again, your new onset date of disability would have to be a date after that ALJ's denial, because that's the final decision. But for these past relevant work cases, because SSA has said that res judicata will not apply, that means that folks can reapply it with the same original onset date. So basically that same claim that was previously decided, and they can likely get a different decision now because of the change in policy. So the only problem for those folks is that if they're more than 1 year from their initial denial, which they likely will be if their claim got denied at a hearing or later in the process, then their original claim can't be reopened. So they'll get less back pay because of the application date. But still, they'll be eligible for ongoing benefits. And hopefully, if they were able to file an appeal and they have a simultaneous federal court case that's still pending, that may ultimately be remanded, which might ultimately afford them an award of all of the back pay.
Thank you, Jennifer, for coming on today and sharing your expertise.
Thank you for having me.
And thank you for watching, and we hope you will check out later videos in this series.